Hi, my name is Ben, and the following video is our landlord guide to the Renters' Rights Bill, which is due to be finalised later on this year. In this video, you'll be hearing from our property managers about some of the legislation that is due to be introduced. We at Mighty Student Living understand that the Renters' Rights Bill might seem like a cause for concern for many of you. We have therefore created an informative video with the information that has been released so far. However, it is worth noting that this is subject to change. The new legislation will be implemented in a phased introduction, meaning it is unlikely to affect next year's tenants and contracts that have currently been signed. However, as previously mentioned, this may change, as the bill is currently going through various stages of consultation, and as it takes more shape, we will provide further updates where necessary. Ultimately, we believe this will bring about good change to the student lettings industry and encourage landlords to maintain their properties to a high standard, whilst working to protect tenants' rights.
Hi, my name's Mikey and I will be explaining periodic tenancies in this video. This new bill will see the end of fixed term tenancies. This means all contracts will now be periodic with no end date, and tenants will be able to serve notice at any point. Tenants are only required to serve 2 months notice, meaning the minimum period a property is guaranteed to be occupied is 2 months. While this may sound daunting, this gives us an opportunity to ensure all the properties we're providing are of a high standard. For joint tenancies, one tenant can technically serve notice for the whole property. This would only likely happen if a tenant had a change in circumstances, for example, dropping out of university. In this instance, the remaining tenants will wish to continue the tenancy, putting more pressure on themselves and the departing tenant to find a replacement rather than terminating the contract. This could be quite advantageous to us, as currently those dropping out or wishing to withdraw from their tenancies can be quite resistant to finding a replacement or paying their remaining rent. Where we might come into more difficulty are instances whereby the entire house wishes to terminate their contract. As mentioned previously, this emphasises the importance of maintaining our properties to a high standard and ensuring our tenants are happy. This will be a major priority for us over the next year, so we'll be able to recommend any improvement works where necessary, or even suggest some incentives which can be provided to add even more value to your properties.
Hi, my name is Caitlin and I'll be informing you of the changes to eviction procedures. One of the major changes that has been a hot button topic in the news will be a ban on Section 21 evictions. These are most commonly known as no-fault evictions. However, this has been a tool rarely used by student landlords because of the short duration of tenancies. Under the new rules, unless there are breaches of the tenancy, the grounds of possession will be limited to 2 reasons. Number 1, if the landlord or immediate family wish to occupy the property themselves, or 2, if the landlord wishes to sell the property. However, all tenants are now provided with a 12-month secure period during which landlords cannot rely on these 2 grounds. Fortunately, there are now strengthened grounds for eviction for antisocial behaviour or rent arrears, which can be exercised within this 12-month protected period. As landlords of student properties, the change to periodic tenancies means that you'll be legally required to give notice to tenancies comprising solely of students. To ensure all students move out of the property on time, we will give them 2 months' notice on your behalf before the date you've informed us you want the tenancy to end.
Hi, I'm Holly and I will be explaining the ban on upfront payments. As a result of assured short-hold tenancies being changed to periodic assured tenancies, upfront payment will also be prohibited. While upfront payments for an entire tenancy has been beneficial for many of our tenants who are international students or workers from overseas, this new Renters' Rights Bill means that this will no longer be an option. So under the new bill, rents will be invoiced monthly in advance. This does not stop the students from voluntarily paying more than a month. The first month's rent cannot be requested before agreements are signed and the tenancy period starts. Under the new bill, pre-tenancy payments are banned.
In this video, I will be explaining the introduction of a landlord ombudsman. One of the key changes to the private rented sector will be the introduction of a landlord ombudsman. This will be very similar to the property ombudsman, but will deal directly with complaints against landlords rather than their managing agents. Registration with the landlord ombudsman will be mandatory, and there will be large fines for failing to register, between £7,000 and £40,000 depending on the number of breaches. The intention is that the landlord ombudsman will be linked to the private rented sector database, so landlords need only provide their information once. The aim of introducing the Landlord Ombudsman is to support quicker and cheaper resolution to disputes between tenants and landlords, reducing the chance of things escalating to expensive court proceedings. There will also be access to a tenancy mediation service which aims to resolve any disputes which are initiated by landlords.
In this section, we'll be talking about tenants' pet requests. The new bill grants tenants the right to request having pets in their home. This will mean that you will not be able to unreasonably withhold consent. Tenants must request permission in writing and provide any relevant details, including the type of pet. However, it does not include assistance dogs. As we have done previously, we will contact yourselves, the landlords, about any pet requests. You now have 28 days to either refuse or give permission for the pets. However, you can ask for more information, in which the tenant has 7 days to respond. We understand that damages caused by pets has been a major reason why landlords have previously denied such requests. This bill, however, will allow you and other landlords to request that tenants have pet insurance to cover any damages, so you won't be responsible for resolving any damages caused at the property. You will also be able to make deductions to deposits given at the start of the tenancy. So, what reasonable reasons do you have to be able to refuse pets? If the property is unsuitable for the type of pet the tenant has, for example, the property is a small top floor flat with no garden and the tenant has a large breed of dog, other tenants are allergic or have been consulted and object, or the pet has a history of poor behaviour, tenants will be able to challenge any unfair decisions they feel have been levied against them. If a tenant chooses to challenge any refusals, they will also be able to go to the courts or to the private rented sector ombudsman. As a landlord, you will also have the right to take the tenants to court to recoup costs if insurance and the deposit do not cover the damages the pet has caused.
In this video, I will be informing you about the private rented sector database. Under the Renters' Rights Bill, the government will launch a new property portal. This will be a database used to communicate changes in legislations and offer guidance across the sector. The main aim of the portal is to help landlords understand their obligations. All landlords on the database will be categorised as active or inactive. In order to stay active, you will be required to keep entries up to date. Updating records will be free. These records will include compliance records such as EICRs and gas certificates, and it is compulsory to submit them to stay active. For those who are active, they will be provided with a unique identifier. You will be required to have this identifier on all advertisements to confirm that you are registered on the database. Without up-to-date records, landlords and their properties will be considered inactive, and you will not be able to market or let your properties until they have been updated. Although tenants will be able to access necessary information in relation to their landlord's identity and compliance with key legislative requirements, not all data will be publicly available. Overall, the key aims of the portal are to help landlords understand their legal obligations and demonstrate compliance, which will in turn allow tenants to make informed decisions when signing their tenancy agreements. We are still waiting on more information as to whether we can provide this information to the portal on your behalf, and we will keep you updated once we know more.
We appreciate that these changes might bring uncertainty, but similar rules came into effect in Scotland almost 5 years ago, and in this time we have seen little or no effect to the student lettings industry. We are also looking at ways of guaranteeing your rental income for the full academic year, but we will provide more information on this once the bill is looking at being finalised. If you have any questions or concerns, please let us know and we are more than happy to help. Please call us on 01524 544 222 or email us at landlords@mightystudentLiving.co.uk. Alternatively, please feel free to pop into our office to speak to one of the team.